I'm
taken.
done. So,
That's
I mean,
ready.
is there anything
You're
else
not
we
done.
need
You're not
before?
done, Mr. Schuster. So I think are you ready on Mr. Schuster's case, Ms. McDonald?
Well, Mr. Schuster, just to give Your Honor a little bit of background on this one, Mr. Schuster is representing himself. The court has previously gone through the waiver of right to counsel. When we were here, I believe the last hearing, Mr. Schuster gave an indication that he wanted to resolve these matters. So I have drafted a plea form with the city's offer on it. I just am not sure how to get it to him. I can certainly send it to him in the chat. I just don't know if he has the ability to download that and sign it in that respect.
Hi,
So,
ma'am. How are you today?
Hold on a second. So
Oh,
the preliminary matter. This is Jonathan Schuster, 4A0525748. So it sounds like Ms. McDonald's trying to get you some documents, Mr. Schuster.
yeah. So for the record, I reserve all rights and retain them. I am making a special visitation for the matters pertaining to Jonathan Schuster, for I am the beneficiary. I had mailed out some paperwork over to the prosecution.
This right here sets the tone. Schuster is representing himself, and already, before the hearing even warms up, we've got paperwork confusion, missing affidavits, and a defendant who clearly doesn't trust the process. This is where self-representation often starts to unravel.
And so,
and I don't know that we've received anything. I'm checking with my office right now, but I don't see anything in our files.
I
emailed to Ms. McDonald this morning.
You did? I'm sorry, what, Madam Clerk?
I emailed to you a copy of the first motion to dismiss and the affidavit.
Yep, there was a motion for dismissal as well as a motion for show cause, as well as the affidavits.
Hold on, Mr. Schuster. Hold on, Mr.
And
Schuster.
so those were sent over
Hold on, Mr. Schuster.
as well as submitted to the court.
Mr. Schuster, hold on a second. Ms. McDonald's getting caught up. I do have your affidavit.
Yeah, I just wanted to make sure I said that. Thank you.
Madam Clerk, did you send that to my email or did you send it to the office email? Because I don't have anything from you today, except the orders from Mr. Bailey Garrison and the borrow out information from Mr. Goodwin.
Okay, if you need time to get that, that's fine.
Notice how he keeps repeating affidavit, like it's a magic word. In sovereign citizen-style arguments, they love to throw paperwork at the court, convinced that technical filings will topple the system. The judge, meanwhile, is already losing patience.
You're talking about on January 27th when the judge denied subject matter jurisdiction? That day?
So the address that you gave to the court on January 27th was the apartment G201. So
the same day that
that was
the
Mr.
judge
Schuster,
denied subject matter jurisdiction?
Mr. Schuster, is that the address you gave on January 27th?
I don't recall, but I do have, somewhere she can send it to. So
Well,
that
we're not going to play the game of you updating your address every court date so that you can avoid service of discovery.
I'm just letting you know that I didn't receive it, and I don't recall. So I'm giving you an address, but
You recognize that address?
which address?
Can you read that one more time, Ms. McDonald?
Yes. The address on January 27th that he requested discovery go out to was apartment G201 in Seattle. The one prior to that he requested was apartment C in Kennewick, Washington. All discovery was sent to both of those addresses.
Do you have the ability to get mail at the Kenyon Street address, Mr. Schuster?
No, I'm not sure why she sent that there.
Because that's the address you gave the court at the end of January.
Well, in January, the judge had denied subject matter jurisdiction, and so
This is classic delay tactic, constantly changing addresses, then blaming the system for not delivering discovery. The judge finally calls it what it is. We're not going to play the game. That's the sound of a courtroom shutting down nonsense.
Do you remember doing the waiver of counsel on December 16th, where you said you wanted to go forward representing yourself?
well, from the very beginning of this
Remember
matter,
signing this piece of paper saying you were representing yourself?
from the beginning,
That's not my question, Mr. Schuster.
Well, I'm answering your question. I would like
I
to
don't want a
speak.
narrative. Yes or no?
Thank
Do you
you.
remember signing this piece of paper?
I don't recall.
Okay.
I
Well,
don't know
your
what paper you're
signature is
showing me.
here on this piece of paper.
I'm not sure what paper you're showing me because
Okay.
it's very far from the camera and
So,
it's
Mr.
just very
Schuster.
hard to read because it's
Okay.
blurry from this
So
angle.
let me read it to you.
So I don't recall.
On December 16th, 2024, you went through a colloquy with Judge Grant. During that colloquy, you engaged in a series of questions about your familiarity with the rules of criminal procedure, criminal courts in general, the Constitution, and so on. At the end of that, you indicated that you have read and completed the form to allow you to represent yourself, and you signed it and dated it and noted you reserve all rights. On that form, one of the things that you are asked to do and acknowledge and understand is that you will be treated as though you are an attorney and you will be expected to follow the court rules as though you were an attorney. One of those rules that you're expected to follow is the Lake Forest Park Municipal Court local rules around how to file and the proper notice of filing motions. The local court rule requires that if it's a motion that is not set on the date of trial, that the expectation will be that you give 21 days notice and properly serve the other party. These motions dropped off, emailed, whatever to the court the day of and the day before the hearing are not properly noted under the local court rules. Nonetheless,
this isn't the trial,
nonetheless, I am going to let you know that I have reviewed the.
Here's the key moment. Schuster once signed a waiver saying he'd represent himself. Now he's trapped by his own decision. The judge reminds him, "You'll be treated like a lawyer." Translation: no free passes, no excuses.
That I've reviewed these motions. There's two of them, a motion to dismiss for lack of subject matter jurisdiction, and another motion that is essentially a show cause motion for the prosecutor to appear and show cause as to why there is subject matter jurisdiction in this case. And what I want to tell you on the record right now is that Lake Forest Park.
The judge drops the hammer. Both motions denied. Jurisdiction belongs to the court. Period. Schuster tried to play the right to travel card, but the judge quickly clarifies. Yes, travel is a right. Driving is a regulated privilege. Huge difference.
What is your current correct address?
The mailing address would be I believe that's Southwest. D?
Unit D?
I don't know how they label it, but it's just D is what I've seen. And then that's Seattle, Washington, 98116.
How do you live there but not know how they label it?
Oh, I didn't say I live there. I just get mail there.
Is that a friend's house? What is that?
Family.
What was that?
And so, just so I'm clear, you're saying that the right to travel and privacy is not a federal matter, and that you're saying that you have the jurisdiction to hear a matter that involves this.
I am saying that there are federal constitutional rights, there are state constitutional rights. Sometimes one, sometimes both, sometimes none are implicated in a criminal case. I'm saying that the Lake Forest Park Municipal Court has jurisdiction over driving offenses that are misdemeanors and gross misdemeanors occurring in the city of Lake Forest Park, Washington, and that the fact that there are federal constitutional rights associated with travel does not preclude the city of Lake Forest Park from filing or prosecuting these cases.
Well, so the right to move freely, which is part of liberty, and a right, because no person shall be deprived of life, liberty, or property. You're saying that isn't a federal.
I'm saying that there are multiple layers of jurisdiction that involve travel, and that the fact that there are federal rights around travel does not preclude Lake Forest Park Municipal Court from enforcing state and local ordinances.
Listen to how he pushes back, almost debating philosophy instead of law. But judges don't debate theory. They apply law. The more he insists, the more he boxes himself in.
Is it your intention to entertain a plea offer from Ms. McDonald?
Well, I just want the court to know that any judgment issued without proper subject matter jurisdiction is void and may be challenged at any time.
And you're free to
This
appeal
court
any ruling from
lacks
this
the
court.
authority to hear this case, and proceeding further would result in an unenforceable judgment. Therefore, this court must be dismissed.
You are free to appeal any ruling this court makes. You can certainly, since you
Almost definitely.
how to do that. Nonetheless, we have to figure out what you're doing today on your case. It's your readiness hearing, where you tell us if you want to go to trial next week or if you want to entertain a plea offer from Ms. McDonald.
Well,
This is where reality hits. Do you want a plea deal, or are we going to trial? The courtroom isn't a debate club. It's decisions and consequences.
so you're not going to send it to the proper address. Okay.
Did that get sent, Ms. McDonald?
Yes, it did.
So, Mr. Schuster, you should be receiving an email from Ms. McDonald. That is Ms. McDonald's plea offer. I'm going to ask that you review that and then let us know if you'd like to accept that today or if you'd like to move forward with trial.
Well, I'm on the Zoom right now.
Right?
And
you
so my
go
email, I'm
go
using the
off
same.
camera and review your email.
What's that?
You can go off camera and review your email.
Okay, so I can just get off and then come back on?
I would prefer if you'd stay signed on to Zoom and just go off of camera and review your email.
Okay. Let me see if I can do this without getting off. Because as I've stated, I don't really know how to use Zoom like that.
If you get disconnected, you know how to get back on it.
Okay. One moment.
Can you mute yourself, Mr. Schuster, and turn your camera off to read your email?
Oh, I saw that Carmen had sent something over.
I guess you need to open it and reboot it.
Oh, it says what you had said on the record, correct?
No, it's an entire form. It's about, see how many pages that is? About 8 pages.
Mr. Schuster, are you reading the document that Ms. McDonald sent to you? Are you reviewing the document that Ms. McDonald sent to you?
Okay, cool. Got it off mute. Oh, so I see everything that you sent over. Obviously, I'd probably have to look at it longer to make sure I
I'm
read
asking
it
you to
carefully.
I'm asking you to do that now. We're going to go back on the record.
Oh, okay. It just might take some time. I've gotten through some of it, but for me to understand what's going on, I definitely would have to read it. I don't know if you have enough time.
And now, tech problems. He says he doesn't know how to use Zoom chat or email properly. If you're representing yourself, but can't open attachments in 2025, you are toast.
25748. Mr. Schuster had an opportunity to speak with Ms. McDonald in the breakout room. And Ms. McDonald, where are we?
Yes, Your Honor, I'm a little bit concerned because it didn't appear that Mr. Schuster was, and I was kind of having a hard time discerning whether or not it was a willingness or an ability to track the conversation.
Oh, objection. I definitely have the ability to have a conversation and track what's going on. I offered her a counter, and she didn't want to take it. And so that's where we are, ma'am.
So I do have some concerns there. Also, Your Honor, I did just pull up his criminal history. It appears that he does have an active warrant out for his arrest for a DUI.
Active warrant?
SMC bench warrant from 2/14/25.
Yes, that is the one. So
Boom. The prosecutor casually reveals he's already got an active DUI warrant. This is the jaw dropper. While he's arguing about jurisdiction, he's literally a wanted man.
Sure, I'm going to ask you some questions. First and foremost, do you know what happens at a trial?
Do I know what happens at a trial? Yes.
Can you describe that to me?
What happens at a trial where we meet and go over the facts and determine whether or not that I will be charged with the allegations against me?
So who decides whether you're guilty of the allegations against you?
Well, of course, it's a trial jury.
So who's on a jury?
Well, my people. I mean, it's a people of, it's The people. Obviously, it's jury trial.
Do you know the difference between a bench trial and a jury trial? What's the difference?
One, there's people who make the decision, and one, the bench makes the decision.
And who's the bench?
Well, I believe I'm speaking with her currently.
So the judge is the bench.
I'm the magistrate.
What are you charged with right now?
You want me to like say it off my memory or read the actual
Tell me
charges from the? Because I have my paper. I can go get it real quick so I can
I
read
don't
it.
need you to read it to me. I need you to tell me to the best of your ability what you're
Oh,
charged.
okay, yeah. You're charging me with, or the allegations are driving with a license suspended, 3rd degree, no interlock device, failure to comply. Is that correct?
Correct.
Yes.
You know what the maximum penalty for each of those charges is?
Not off the top of my head, no way. I'd have to look at my notes.
The judge quizzes him on trial basics, jury versus bench trial max penalties, and his answers are shaky at best. If you can't even define the process, how are you supposed to defend yourself?
Which was very reasonable. She declined. And so the next step would be, for this court would be the 11th at 9 a.m. Is that correct? Is that the right time?
That's correct. Ms. McDonald, do you have the ability to send over the electronic discovery to the courthouse for Mr. Schuster to pick up?
So we would have to, so the electronic discovery, we have the body worn camera and all of that information that had to be burned onto CDs and sent to him because it's too large to send.
You said
via
CDs?
email. So that was all sent out to his address. We would have to
You
redo
said
all
with
of
CDs, you said?
this.
Some of the body worn cameras on CDs because it's too large to send any other way, Mr. Schuster.
You still use CDs? Is that what that is wild.
Well, you are held to the same standard as attorneys, and attorneys are expected to.
I'm just surprised that you still use CDs.
Is there that your office could, ABC Legal or something like that your office could get that over here quicker than the U.S. mail?
Well, we would certainly be able to bring it to our office. Isn't that far from the courthouse, so it's not a difficulty in the transportation. It's just
Even the CD comment is telling. He's mocking the court for using old tech, while forgetting the point. That CD holds the evidence against him. Laughing about it won't save him.
McDonald's office make you another copy of the discovery, burn the electronic medium onto CDs, and it's going to be available for you here at the court window after 10 a.m. on Friday. That is going to be the only additional discovery that you get. You need to find a way without driving to get here or get someone here to pick that up for you. That will be the only additional copy of the discovery for you. We'll be here at the courthouse for you to retrieve. The courthouse is closed on Saturdays and Sundays. So if you want to prepare for your trial, I recommend that you come Friday after 10 a.m. to do so.
This part is almost painful. The judge literally bends over backwards, ordering brand new CDs, making sure Schuster gets them, warning him this is the last chance. Courts don't usually hand out extra lives. If you get a judge spelling it out this clearly, it means your time for excuses is almost up.
So, who was the injured party exactly?
The city of Lake Forest Park has filed charges.
City of Lake Forest Park. Okay, and they'll be present at the trial. I'll be able to face them.
They are represented by Ms. McDonald's office.
So the city is the plaintiff as well as the judge. Is that what you're saying?
The city is not the judge.
Lake Forest Park is not the magistrate for this matter?
Lake Forest Park is the municipality in which this court takes place. Judge Grant will likely be here next week. She is the judge. She does not represent the city. The city is represented by Ms. McDonald's office.
So the judge doesn't work for the city at all, is what you're saying?
She is a neutral arbiter of matters. She is not representing the city.
So she doesn't work for the city.
No, she works for the courts and the court system.
Ah, okay. And
So, Ms.
during
McDonald,
trial, the prosecution will be able to bring the injured party forward, correct?
during trial, the prosecutor will be afforded the opportunity to bring forth its witnesses. I suspect that will be.
The injured party argument is peak sovereign citizen logic. They want a flesh and blood victim. But in criminal law, the state itself is the victim. Here, it's the city of Lake Forest Park. End of story.